For someone getting a divorce, Social Security may be the last thing on his or her mind. How can the timing of the divorce affect one's financial position? Live at 5's family attorney Sonia Kaufman joins us now with more. Social Security not on a lot of people's mind.
Probably not at the time of divorce, but it's important to know that if you've been married at least 10 years, you can draw on your ex-spouse's Social Security record. So I had a lady not so long ago in my office contemplating divorce, and she had been married about 9.5 years, and I said, well, wait, you need to think about this.
Can you wait for 6 more months?
Exactly. If the marriage lasted 10 years or longer, and the applicant is at least 62 years old, and if your ex-spouse is eligible to draw either retirement or disability benefits from Social Security, then you can make application to draw on their record if that amount is greater than what you would get on your own record.
And how would you know that?
You visit the local Social Security office and they'll give you that information. You have the election. It's either 50% of the ex-spouse's amount or 100% of your amount, whichever is greater. And it's also important to know that your ex-spouse doesn't have to consent to this. His benefit won't be affected by that. It's just in addition to what he received.
And it may actually help you out, especially if you've been a stay-at-home mom.
Exactly, and have not worked. This is a good option. It also can be a good option for someone who would like to begin drawing Social Security but who's not 67, because for some people that's full Social Security benefit age. So you could draw on your ex-spouse's benefit at 62 and delay drawing on your own benefit until 67, which would most likely result in a higher benefit to you.
So definitely something that you'd want to look at.
Absolutely.
And we've got some questions on our KFTM News Facebook page. One person writes, my ex and I share custody of our son. My papers say I have to live in Jefferson County, but I want to move to Vidor for the school and my job. If I do, what will happen?
Well, I would advise this viewer to check her papers very carefully, because usually the geographic restriction says Jefferson and contiguous counties, which would include Orange County. And if that's the case, then she needs to follow the directions in the papers about giving the proper notice to her ex-husband. But if, however, it truly says just Jefferson County, then she's in violation of that geographic restriction.
And he could, in fact, take her back to court?
He could enforce that. He could file either an enforcement or a modification of custody. So I would say she needs to go back to court to get that lifted before moving, if that's what the papers say.
Okay, and real quickly, is it possible to sue your ex for ruining your credit?
Most likely not, because under the doctrine of res judicata, any claims that you have against a spouse need to be brought as part of the divorce. So if they're already divorced and this conduct happened during the marriage, it's probably too late.
Okay, Sonia, as always, we appreciate you taking the time to stop by. And if you have a question about family law, let Sonia answer your questions. You can fax those questions 892-7305, email us at laf@kftm.com, or post them on our KFTM News Facebook page.